in its entirety, and in particular clauses 1 and 2 to the House.
Call Andrew Little.
Thank you, Mr Chairman. It's a pleasure to take yet another call on the legislation bill, which, as my colleague has pointed out, is a very important piece of legislation, and it is curious, given what the bill does in relation to the status of legislation, of completed and concluded legislation, the publication of it, and the role of the Parliamentary Counsel's Office, that it should be given such a bland and unappealing and really uninformative name as the legislation bill. And really, I think, if we are serious and want to meet the spirit of this legislation itself, then we will find a more creative name, something that in fact does it justice, no pun intended. Sir, I relay a recent experience I had. I found myself yesterday in the company not only of a QC and one or two other lawyers, but actually of a High Court judge, in an interesting exercise which I won't go into. I was at the Auckland High Court, and I don't want to go into too many other details, except to say it was a very satisfactory outcome for all concerned. Very satisfying outcome, satisfying and satisfactory outcome for all concerned, particularly that party that I think had the biggest legal bill to pay. But anyway, the point is this, is that while we were there engaging in a very mutually satisfying and satisfactory conversation with all concerned, this was before we held hands and exchanged beatific smiles with each other. But the High Court judge, a most respectable and an honorary fellow, came to the room equipped with large printed and hardbound editions of legislation and of a highly respectable legal text. And I sat there in that room observing this highly respectable and honourable High Court judge, thinking, now if only His Honour the Justice had the benefit of the legislation bill currently going through Parliament. As that I did think that. In fact, I was about to make it. In fact, were it not for other issues that were occupying those of us who were there, I might have raised the issue, because His Honour the Judge would have been most assisted by an electronic publication of the legislation that he was consulting at the time, that from memory I think was something like the Defamation Act 1992, although I could have that wrong. It was a large bound volume of legislation. And I thought to myself, isn't it a pity that at this very point it is not a requirement that an official version of the legislation is published electronically? Because had that been the case, then His Honour the Judge may well have been able to turn up with a nifty little iPad or even a laptop or some other handheld device that he could have brought his legal texts along with him, and would have saved him having to wander through the vast, cavernous regions of the Auckland High Court to come to our little room to play his very important role. So that's why I think it's very good about this legislation, and why...
Sorry to interrupt the honourable member. The time has come for me to report progress.
The House has resumed. Mr Chairman.
Mr Speaker, the committee has given further consideration to the legislation bill and report's progress. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Contrary, no. The ayes have it. This bill is set down for further consideration in committee next sitting day. And it's now time for the House to be adjourned until 2 p.m. on Tuesday the 27th of November in the year 2012.